During this pandemic, parents are confused as to what to do when it comes to their custody and access arrangements. They are rightly confused because they're listening to the news which says maintain self-distancing, and at the same time they may be under an obligation by way of a court order or a separation agreement to have the access arrangement to continue. In this video, I will give you multiple examples and scenarios to help you understand how to approach this problem. Mind you, I'm only providing general legal information. I'm not giving any legal advice to individual people who are listening to this video. If you want legal advice, I would suggest you retain a lawyer who would sit down with you for an hour and a half, understand your facts and circumstances, and then provide you a tailor-made legal advice, which would be applicable in your situation. The purpose of this video is merely to educate people and provide legal information which is general in nature. So my first example would be, let's say you or your child or anyone is under self-isolation or quarantine orders. This example is fairly simple. If you are under self-isolation or quarantine orders, then you do not have to comply with the terms of the court order or the separation agreement. Theoretically speaking, you may be in violation of the court order, but there is an exception because you have been advised by the doctor and by the government to self-isolate. However, what is important for you to understand is that your self-isolation orders are only for 14 days or maybe 20 days. So you cannot use this situation as a blanket approval to prevent the child from going over to see the other parent. This is only on temporary basis when it is not safe for the child to go over to the other parent's home. Now, what I'm noticing is that many people are finding that the default position would be not to send the child over to the other parent's home. In fact, the default position is to follow the court orders or to follow the terms of the separation agreement, unless you have been specifically told to self-isolate and only for a specific period of time. Once you're out of self-isolation, then you're free to follow the terms and conditions of the court order. Second example would be where a parent receives positive test results for COVID-19 and they don't want to share this information with the other party. Well, if you don't share this information with the other party, you are putting yourself at risk because at the end of the day, both parents are entitled to know about the health and welfare of the child. Therefore, any report pertaining to the health and welfare of the child is material information. If you do not disclose this information, test results being positive or negative, you are withholding material information from the other parent. Let's say you are of the opinion that the other parent is not observing COVID-19 protocol by self-distancing from other people. You are of the opinion that the other parent is perhaps participating in parties, is going in social gatherings, etc. Well, in that situation, the protocol should not be to withhold the child from going over to the other parent's home. The way to approach this problem should be have dialogue with the other party. And the dialogue should possibly be by way of an email, because at least you can print those emails to show that you attempted to resolve the situation. And in that dialogue, what you're attempting to do is basically suggesting to the other parent, please maintain social distancing, please maintain COVID-19 protocols as suggested. If the other party agrees, well, bingo, you have solved the problem. If the other party doesn't agree, then you have the option of going to court by filing an urgent motion in court. Yes, the courts are open to hear urgent motions, and this would fall within that category. But what you need to know is that you can't just get up and file an urgent motion without any reason. You would have to establish that you attempted to solve the problem, you have doctor's orders, or there was a reason, there is sufficient evidence. You would have to file an affidavit establishing that you have information that the other party is not following COVID-19 protocols, and you attempted to request them by way of an email, please do so. They ignored it. In such situation, of course, the courts are going to come for your rescue. The law would not want the children to be put at risk. But at the same time, the law encourages frequent and maximum contact with both parents. You should not be taking advantage of the current situation by not sending over the child to the other parent. In another example, let's say you have a situation where the doctor says the child has a weak immune system. If the child has a weak immune system, but the doctor is of the opinion that after taking certain precautions you can send over the child, then you should follow the court orders of the terms and conditions of the access. If you don't, you are in violation of a court order. I hope the information that I've provided was helpful and useful. You can always visit us at our website at slclawyer.ca, or send us an email if you have any questions at info@slclawyer.ca. Thank you for watching. Have a great day.